All rise. Court of Appeals, Division 1 is now in session.
Good morning. Thank you. Please be seated. This is a time set for oral argument in our case number CV14 0299, Robert and Ketlin Rader versus Greenberg Traurig et al. Counsel, each side is allocated 20 minutes for oral argument. Appellant, you may reserve any amount of time you wish for rebuttal, but you'll have to keep track of your own time. There is a clock at the podium, and I'd encourage you to do that if you wish to. Out of respect for counsel, I would ask that everyone in attendance make sure that your cell phone is turned off or disabled so our presentations are not interrupted. We have reviewed the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded and will be posted to YouTube in due course, so please, as you approach the podium, state your name and the party that you represent. With that, let's first hear from Mr. Weaver.
Good morning, Your Honors. My name is Brett Weaver, and I represent the plaintiffs and appellants in this matter. With the court's permission, I'm going to try to save 5 minutes of my time for rebuttal.
Very well.
To have an to have an honest debate about cross-jurisdictional tolling, both sides need to concede a couple of points. The first is only a small fraction of the states have actually considered this issue. Second, those states that have considered it are split almost evenly down the middle, and I would concede that they have maybe one or two more cases on their side than we have on ours. And third, there are reasons both for and against cross-jurisdictional tolling that this court could accept no matter how it wants to. On balance, however, the arguments favoring cross-jurisdictional tolling outweigh those against it and are more consistent with Arizona's policy favoring resolution of cases on their merits and disfavoring application of statute of limitations defenses. As you pointed out, you've read the briefs, and those briefs go through all the reasons for and against cross-jurisdictional tolling, so I'm not going to repeat them all here today. Let me just focus on the two main arguments against cross-jurisdictional tolling. And the first one is the idea that if you allow absent class members to file individual claims after their limitations period expires, you are going to open up the floodgates and drown state courts with all kinds of stale litigations. As we pointed out, there is absolutely no empirical evidence whatsoever to support that conclusion. If anything, the data suggests the opposite. The number of new cases that have been filed in states that have rejected cross-jurisdictional tolling has outpaced the number of new cases in states that have adopted it. And I would be the first one to admit that there are probably a whole host of factors that play a greater role in those litigation trends than cross-jurisdictional tolling does. But certainly, if cross-jurisdictional tolling is going to open up the floodgates and it's going to make states clearinghouses and invite a disproportionate share and, to quote another court, make them the focal point of these litigations in the clearinghouse, by now there should be some data to back up that conjecture. And there just simply isn't. None of the cases that have rejected cross-jurisdictional tolling have cited any evidence. Greenberg certainly hasn't cited any evidence. I think it's clear that all the speculation about the floodgates is, to borrow the phrase from the Arizona Supreme Court that I think is relevant, is it's the fabled cry of the wolf. The other argument against cross-jurisdictional tolling, and the one that Greenberg seems to hang its hat on the most, is the idea that cross-jurisdictional tolling prevents forum shopping. Well, the Ohio Supreme Court in the Vassarello case said this is not a realistic concern, because even if a state adopts cross-jurisdictional tolling, absent class members can't file there unless the case has some connection to that state. And while Greenberg has taken us to task for not filing this case in California, it's yet to explain what possible basis we would have to file it in California, other than the fact that less than half of our plaintiffs reside there. This case, again, arises out of an Arizona-based Ponzi scheme that was aided and abetted by Arizona lawyers based out of Greenberg's Phoenix office. There's absolutely no connection to California. If we filed this case in California, we would have had bigger problems than the statute of limitations defense.
So, Council, you've outlined the policies, or sort of the consequences, if you will, the ramifications if cross-jurisdictional tolling is adopted or not adopted. You've kind of laid those out. You laid those out in the briefing, and again here this morning. But why, as a starting point, why don't we turn to why isn't the focus on what the Arizona legislature has done in this realm, i.e. with regard to statute of limitations, and particularly I'd like to have you direct you to the savings statute, the 12504, right? There's 12504, because I'm reading from the Albano case where the court is quoting American Pipe, I believe, and they say when determining whether to apply class action tolling, the proper test is whether tolling the limitation in a given context is consonant with the legislative scheme. So shouldn't that be like the number one focus for us, is let's determine what the legislative scheme is and see if tolling would fit within that scheme?
I think that's correct, Your Honor. I think it is consistent with the legislative scheme. The fact that the legislator has never confronted this issue is not a reason not to say it's not consistent with the legislative scheme.
But they have adopted like under certain circumstances, I mean, that you can take advantage of a savings statute, right? If you fall within in those parameters.
And I would point out that the reason that Arizona's legislature adopted the savings statute is the Supreme Court in Hosagi begged them to adopt the savings statute. But nevertheless, even without that savings statute, the Hosagi court still told the statute of limitations under fairly relevant circumstances to here.
Well, although different than the procedural context that brings you here today.
Exactly.
But let me ask you, and if you were here and only Hosagi existed, in other
Right.
words, 504 didn't exist, it would be a lot more akin to American Pipe in the federal system where there is no general savings statute. But Hosagi placed a literal call, they used the word, to the legislature, and the legislature answered that call in enacting 504. How are we to construe what effectively, you're either asking us to interpret the provision of a limitations period in the general savings statute to put language that I think fairly doesn't exist in those statutes, or you're asking us to adopt something as a matter of common law when the legislature has enacted a statute in response to our Supreme Court's request.
As you pointed out, Hosagi was a different factual scenario. Again, the fact that the legislature hasn't gotten around to adopting this, I think is not indicative of an intent that they don't want to have cross-jurisdictional tolling. Just, it's more indicative of the fact that cross-jurisdictional tolling rarely comes up.
Well, but hasn't 504 been applied in considering subsequent cases where cases filed in federal courts have been dismissed?
I'm not aware of cases filed in federal court. The one that I am aware of that I think is extremely relevant here is the Templar versus Zell case. And that was the case where the plaintiffs sued their accountants in Illinois state court for malpractice. And the Illinois court eventually dismissed the case for lack of personal jurisdiction. Plaintiffs quickly refiled it here in Arizona. And the question was whether the filing of the case in Illinois triggered the savings statute in Arizona. And the Templar court, rejecting the majority rule of states with similar statutes, said yes. And the reason for that is because the filing of the case, no matter if it's in Arizona or Illinois or wherever, puts the defendants on notice. I would note that's the same policy. One of the main policies behind cross-jurisdictional tolling is that the class action, no matter where it's filed, gives defendants notice of the claims against it.
But how are we then to account for 504 in this case? 504 was not invoked by your clients, is that correct?
Correct. And it's not invoked by your clients because 504, by its term, only applies to parties or their successors in interest. There is plenty of case law, federal case law, United States Supreme Court case law, that says the absent class members are not parties to a class action.
Even when there's a class that's certified and even when they're bound in a preclusive way from the judgment in a class?
Well, they are bound in the preclusive way except for the settlement. And the reason they're not bound is the United States Supreme Court 30 years earlier in the Schutz versus Phillips Petroleum case said class members have a due process right to opt out of a class action and not accept a settlement. And that's precisely what we've had here.
But, and your view, okay. It seems to me then either your clients were members of the class and therefore at least putative parties to the class action, or they weren't. And I think, in my mind, they were and then they opted out, meaning they no longer are.
That's right.
And there, from your perspective, then 504 could have no application to that.
I don't think so, Your Honor. I think 504 was intended to address a different scenario than effectively cross-jurisdictional tolling. And again, I would note that cross-jurisdictional tolling isn't a statutory creation in any of the states that have adopted it.
Wait a second, counsel. They weren't voluntary. They weren't. What was the nature of the dismissal from the class action? I mean, they were dismissed from they opted out, but that couldn't be considered a voluntary dismissal?
The case was voluntarily dismissed. My clients exercised their right to request exclusion from the class, whether that's a voluntary dismissal, maybe de facto, maybe in all practical sense, yes.
Pursuant to a court order, right?
Correct.
And had they remained, had they not opted out, they would have been a party of that class and bound by the judgment or settlement order that resolved that case.
Correct.
Okay.
But again, the whole point of the request for exclusion process, which is guaranteed by the due process, is to allow class members to opt out and to go their own way if they want to.
And I understand from a Rule 32 perspective. What I was trying to understand a little bit better was from a 504 perspective, and I'm still not sure I'm there.
Okay.
So.
The only, again, what I would suggest is that 504 is intended to cover a circumstance where, like in the Temple case, where plaintiffs file in a different court, that case gets dismissed for whatever reason, voluntary, involuntary, whatever, and they refile. It's not intended to apply to class actions. Perhaps it could be stretched to apply to class actions, but I don't think that's what the intent was. I don't think that's what the language suggests. And even if it did, I think there are circumstances. The court, as the court in the Hosagi recognized, the court has judicial power to toll circumstances, particularly when here it impacts the court.
But Hosagi, it felt, at least as I read the decision, felt uncomfortable in doing that. And that's what resulted in the call to the legislature. There was a squeamishness in that decision about whether this is a legislative thing or a judicial thing. And they said in that case, as you point out, it was a judicial thing. They equitably told, but what other reason would there be for the call to the legislature if they weren't uncomfortable with that approach?
I think to just give finality and give an easier rule for courts to apply, because otherwise you have it come down to considerations of equity in every case. And the idea there was, well, let's just have the savings statute, which is not uncommon. Many states have it.
Many states do, and the federal court doesn't, though.
Correct.
Which in one way distinguishes the body of case law applying American pipe and its progeny. When you look at the state side of that, there are states, many states, with general savings provisions. And again, if we were here just after Hosagi but before 504, I think your argument would have more traction than it does. But I still struggle with the concept of 504, which was enacted to expressly address, and maybe not to the satisfaction of you and your clients, but to expressly address this type of situation.
Well, Your Honors, if your finding is that 504 would have applied, if my class members could have, or that my clients.
And it's a different point than that.
Okay.
It's that the legislature enacted 504 as a general savings provision, and your argument now, notwithstanding the statute of limitations and the general savings statute, is that the court ought to do something different than what's reflected in 504.
I would be arguing that the court should fill in a gap that has been unaddressed by the legislature.
And that's where I get back to the Hosagi. The court felt it seemed squeamish in doing what it did there. And now, having called for the legislature to do something, the legislature having done something, you're now asking us to do something in addition to that.
I would point the court also to the hydroculture case that we cited. And off the top of my head, I don't know if that was pre-saving statute or not, but I would point out that was a case where again, an accounting malpractice case, where the debtor filed a counterclaim against the accountants in bankruptcy court. And then and then the case was dismissed years later, eventually refiled the case in Arizona Superior Court, and on statute of limitations, the court agreed that there were tribal issues of fact as to whether they acted reasonably in filing that claim in bankruptcy court. Again, it's just this general rule that Arizona courts have always been favorable to not kicking cases out of courts where plaintiffs have not sat on their rights. They participated in an action, either directly filing one or, in this case, participating in a class action. Because, again, the policies of the statute of limitations are to prevent plaintiffs from sitting on their rights and to protect defendants and the courts from stale claims. And we have neither of these situations here. There has been no prejudice to Greenberg. The only prejudice they can point to is the fact that we may have lost our documents or our memories may have faded. But even if that's the case, the prejudice is ours. Unless the court has any questions, I'll reserve the balance.
Thank you, counsel. Thank you. Mr. Sir,
Smierczynski, it's not easy.
Well, with a name like Thumma, I appreciate that, but thank you. Please proceed.
May it please the court, Ken Smierczynski for the appellees. In this case, it's undisputed that, absent the application of some tolling doctrine, these claims are time barred. It's also undisputed that, despite the wealth of statutes in Arizona dealing with tolling, that these claims aren't saved by any of them. And we just heard and had confirmed what's evident in the record, which is that the saving statute was never sought to have been applied by appellants at any level, either in the trial court or in the briefing here, nor could it be, as they concede quite properly. Finally, Arizona recognizes the doctrine of equitable tolling, the common law doctrine. It's not asserted to be met here either. So there are a wealth of statutory and judicial precedents in Arizona that address this topic. It's conceded none of them save these claims.
Why doesn't 504 apply?
Why doesn't 504 apply? Well,
First off, I
it's
understand
been
that
waived. It's been, but let me address it in any event. It doesn't apply for two reasons. The first is, as appellants concede, they were not parties in that case. They were putative class members, and so it doesn't apply because they weren't a party. Secondly,
Does the statutory language bear that out, or is that a construction under Rule 32 or 23 of the federal rules?
I think it's a construction under Rule 23, Your Honor.
Because I'm sort of guessing you represent a client in a class action that admittedly is not before us, but when that is resolved, I'm sort of guessing your client would claim that was preclusive as to all class members. At
that point, yes. But, for example, you can't get discovery of absent class members in a class action. There are a host of they're not bound until there's a final determination. Yes, at the point of a judgment, they are now bound by that judgment. But up until that point, they're not bound, and so they're not a party. They have the right to opt out, as has been pointed out here. Secondly, Your Honor, the saving statute's designed to protect people who perhaps file in the wrong court, perhaps err in service of the complaint, or are dismissed for some administrative reason. That's not these folks here. These folks here knew they had a claim, decided not to pursue it, but to wait and see what happened in another action. That was a voluntary decision. And then decided to opt out and try and bring a stale claim here in Arizona in a different court system. So I think the saving statute doesn't even apply, but even if it did, at a minimum, we'd be in the second portion of the saving statutes. That this is, I guess, akin to a voluntary dismissal. I don't think you even get there because I don't think they were a party, as has been conceded, and I think is the right way to look at it. But even if you somehow got into the saving statute, you'd be talking about the discretionary portion of the saving statute, and that is where there's been a voluntary dismissal.
Or what would be your opinion if the class had not been certified?
do you think the saving statute would apply then?
If the class had not been certified, I think at that point, it's in some ways as if no action had ever been filed as to those absent class members. The court basically has said, no, this was an improper attempt to bring those people in and has rejected it. Now, again, I don't think they're parties. I think it's a different situation, as has been discussed.
Don't you then get right into the jaws of American Pipe? If you're saying Arizona effectively, for claims like this, has no general saving statute, and class certification was denied, that's American Pipe.
That is American Pipe, and American Pipe has been, there are different versions of American Pipe, as we're now here talking about.
Sure.
But yeah, you have raised...
and American Pipe plus its progeny saying, hey, you don't have to interplead. You can file a
right, and Cork and all that.
Yeah.
But my point is, yes, now you're facing the American Pipe issue. I agree with you, Your Honor. And the question is, how should Arizona deal with that sort of American Pipe problem? And that's what brings us here today, because none of the existing statutes, as have been conceded, in fact, revive their claims. So the question is, how should Arizona deal with the American Pipe problem? And our first argument is that that's a legislative decision. As the court did, as you noted in Hasagi, there was squeamishness, and I think that's an excellent word to describe how the Court of Appeals reacted to that problem, that beseeched the legislature to fix it. The legislature then fixed it, and that solved that. We see in Albano, which addresses this general area of class action tolling, that there's a concern that acting to allow the claims there would impinge on the legislative judgment. We see it in the Flores case. We see it in the Lagerquist case. And I think actually, although it's not a statute of limitations case, perhaps the most interesting case and apt case is the Windsor case, which involves successor liability. There, the plaintiffs argued that the doctrine of successor liability should be extended in Arizona to include this notion of product line exception and continuity of enterprise exception. And in other states, courts by judicial fiat had extended it. Some had not. This court, the Court of Appeals, said, while we might have the judicial power to do that, we shouldn't. This is a policy judgment, and we should leave it to the legislature. And that's where we are here. There's no question that this court has judicial power to consider matters of statutes of limitation, the exact scope of the discovery rule, et cetera. But the question is, should you exercise it?
But why didn't the U.S. Supreme Court say that same thing? Why didn't they say, look, Congress, you can deal with this. We don't have any business getting involved in saying when the tolling should occur. This is a matter of legislative concern.
I think because the United States Supreme Court is far more activist than the Arizona Supreme Court. And it was much more comfortable saying, we are going to grab this and create a doctrine. I think the Arizona court system hasn't had as activist of an approach. And I think Windsor is a perfect example.
You could probably get some argument about that from our legislature, but
Well, I will resist getting in that debate today. But I think Windsor is exactly on point and is instructive. In Windsor, in these other states, the courts had extended these doctrines to expand what was the scope of successor liability. And this court said, yeah, we have that power, but we shouldn't do it and we won't. It's up to the legislature to do that. And so I think we have that here as well. This is a policy judgment. This is a policy judgment as to whether the state courts of Arizona are going to be open to claims that were filed somewhere else in a class action. And are you going to open up your courts to those claims? And the answer is you shouldn't. First, because that's a legislative decision, but secondly, for all the reasons that courts have rejected it. We heard some reference to to the reasons why they have, but let me try and do justice to it.
Let me ask you before you go
Certainly.
there, and I want to hear from you on that, but, you know, you have acknowledged that Arizona courts, as a matter of common law, if you will, have adopted equitable tolling concepts that seem to peacefully coexist with the separation of powers. Is that fair?
Absolutely, there's no question about that.
Isn't American pipe sort of one type of equitable tolling?
Well, in Albano, the Supreme Court of the state said whether it's equitable tolling or legal tolling, we're not really quite sure, and there's been a lot of debate about that. And I think
It also said they didn't have to really decide the issue there, right? I mean,
absolutely.
and
but-
they were dealing with a statute of repose, if memory serves, which is a very different sort of animal than a statute of limitations.
Yes, no, I agree. The court didn't reach that issue. It said that it didn't think that it fit neatly into either category. Albano, and this is, I think, important. There's a wide recognition with regard to American pipe tolling, though, of course, Arizona hasn't reached it yet. But what's interesting about Albano is when you come to statutes of repose, the courts outside of Arizona are somewhat split as to whether American pipe tolling applies in that situation. Albano said, we're not going to expand American pipe tolling to reach statutes of repose. We have a sort of similar situation here. Courts outside of Arizona are split on whether cross-jurisdictional class action tolling. It's a mouthful.
It is.
That's at least one reason to reject the doctrine. But class action, cross-jurisdictional tolling should not apply. And as a predictive matter, it suggests the Arizona courts should not extend the American pipe tolling doctrine that far. They haven't even adopted the tolling doctrine to begin with. To leap in and extend it seems to me counter to how Albano thought about it. Now, so respectfully, I think this court shouldn't reach the policy decision. Should decide that's a legislative determination. Even if you have the power, you should decline to exercise it, as the Windsor court did. But if you reach it, there's sound reasons to reject this doctrine. What this doctrine does is it takes a claim that is stale in Arizona and it revives it. As the Fourth Circuit in Wade said,
Go back. Explain what do you mean by being stale? Why was the claim stale?
the claim was stale because in 2008, Mortgages Limited declared bankruptcy, and there's really no question that at that point in time the claim accrued. These plaintiffs did not bring their action in Arizona until 2012. So
Understood, but just assume that let's say that it would have been, the case would have been bumping along in the class action in the federal court for years. Could have been, conceivably, right? It could have gone on for 4 or 5 years. I mean, so to cut to the chase, how were your clients prejudiced or denied any rights by them going down the street to a different courthouse?
back in 2010, let me back up, and this goes to the equitable tolling issue as well, and just cast a little bit of the history here, because I think it speaks to why there's no equitable tolling here and why it's not unfair for these plaintiffs to be unable to pursue their claim. In 2008, as I mentioned, Mortgages Limited declared bankruptcy. Greenberg Traurig had advised them. In 2009, the appellants and others sued the estate of Scott Coles, who was the CEO. They also almost uniformly entered into a tolling agreement with Greenberg. This is in 2009. They're well aware that they have a claim. They're well aware that they have a statute of limitations issue. They let that tolling agreement lapse. Many of the folks who signed that tolling agreement brought claims in the Maricopa County Superior Court. That was the Marsh case, the Ashkenazi case, and the victims' recovery case. Those cases proceeded on a consolidated basis. They were eventually settled. The federal action was eventually settled. These cases could have all been coordinated. These folks decided not to pursue their claims then.
But how does that prejudice your client? That's still not, getting to the question that Judge Brown asked, which is prejudice to your clients. The fact that it's the same case back in 2008, 2009, in Superior Court, in federal court, with the class action. How is your client prejudiced by that?
My client's prejudiced by that because memories fade. We haven't had an opportunity to depose the plaintiffs. Their memories have faded.
And that's prejudice towards them, though, isn't it?
No, it's prejudice towards us because it's quite possible that they would admit they never read the documents. They had no idea who Greenberg was. Their investment decision had been made based on representations made to them by Scott Coles, not something in an investment document that Greenberg happened to have edited or the like. Let me say, when it comes to equitable tolling, the courts are clear. There's always prejudice to the plaintiff. They're out of court. That's not enough. If it were, every time you'd have equitable tolling, the plaintiff's claim would go forward. And the courts of Arizona have made very clear that that's not enough. They had to show something else. These folks had numerous opportunities to pursue this claim. And I'll add, amongst them was when they opted out, they were informed in writing that they had this problem. And there were a number of other individuals and marital communities who had opted out, and they opted back into the case because the settlement gave them that power. They realized, my gosh, I have a serious problem. And so they opted back in. So these folks are the antithesis of someone who's been prejudiced.
Would it be proper on this record, which comes to us from a motion to dismiss, to delve into prejudice? What basis in the record would there be for us to consider that as opposed to a remand to allow the trial court to consider that on a more fully developed record?
You could do that, but I think you don't need to because they haven't invoked equitable tolling. They haven't invoked any statutory scheme that saves them. I think the point of referring to those equities and the like is to explain that this is certainly not the case where this court ought to stretch to create a new tolling doctrine out of whole cloth. That's never been recognized by the legislature, that the Supreme Court hasn't even taken the first step towards by recognizing American Pipe. So I don't think you need to reach the question of whether there's prejudice or whether the equities are met here. I simply point out this is hardly the case in which you ought to go do that. Let me address the due process argument that was raised as well. There's no question that there's a constitutional right to opt out of a class action. Though there's really a footnote to that. There's certain mandatory classes and injunctive classes where that may not be the case. But as a general matter, certainly Schutz says that. There's no constitutional right, however, to bring a stale claim in another court system. No court's ever said that. No court ever could say that. These folks, if they wanted to opt out, could have. Their at an earlier point in time, their compatriots did. They brought claims in state court. Those claims proceeded. No one argued they were time barred, and they've been resolved for the most part. Footnote I don't need to get into. But the point is, they had that ability. What they don't have a constitutional right to do is play a game of wait and see. Let's see how that class action goes. Let's see if we like the result. If we like it enough, we'll take it. If we don't, we'll bring a stale claim in Arizona State Court. That's not a constitutional right. That's playing an option. And they got burned. And they did so after being, again, fully warned that they faced that. They could have opted back in. They understood the risk, and they took it. It was a bad mistake on their part, but they did it after being warned and being advised by counsel, and it's not this court's job to save them from that. Unless the court has any other questions, let me rest. Thank you.
Thank you. Mr. Weaver, rebuttal.
Thank you, Your Honor. Briefly, let me start with one of the last points that was made, and that is my clients could have opted out early in the process, and they could have done what other plaintiffs had done, and they could have tried to litigate this case. That's the whole point of cross-jurisdictional tolling. You don't want parties opting out of cases early on and burdening the courts with duplicative placeholder lawsuits. As for the letter that they keep bringing up, the letter was written by class counsel who my clients had already lost confidence in. And it's clear that the reason that letter was sent, not to give a warning to my clients not to make a mistake, it was to save the settlement. And without disclosing attorney-client communications, we, of course, gave the letter to the clients and told them what any prudent lawyer would do is, it's a coin toss. Arizona hasn't adopted it yet. Some states have, some states haven't. We're not trying to weave a doctrine out of whole cloth. It's not as if there are 30 states who have said no to cross-jurisdictional tolling and none who have said yes. It is a coin toss. And if plaintiffs don't take these types of gambles, how does the law ever evolve? One thing I want to mention about Albano is, again, there were 3 questions. And the first was, does American pipe tolling apply to the statute of limitations? And the Albano court says we assume without deciding. If the saving statute occupied the field for statute of limitations, if there were no circumstances where a court could exercise judicial power, why would it say that? It would have been much easier to say the saving statutes occupy the field. This is exclusively a task for the legislature. But it didn't. It went through, and as you pointed out, it distinguished the significant differences between statute of limitations, which is, as it pointed out, is a procedural rule, and statutes of repose, which is a substantive rule. And let me just finally conclude by, the whole argument seems to be that we're not entitled to exercise the saving statute. We're not entitled to exercise equitable tolling. We're not entitled to exercise any of the other statutory tolling rules. And so I ask you, what's then our remedy? Other than accepting a class action settlement that we have a due process right to reject. Again, it's our position that under these circumstances, rejecting cross-jurisdictional tolling makes that entire class, that opt-out process, completely illusory. Unless the courts have any questions, thank you for your time.
Counsel, as is obvious by our questions, I hope you've given us much to think about. We appreciate it. We will take this matter under advisement. We'll issue a ruling in due course. We're now going to take a short recess so we can set the courtroom up for our next argument. Thank you.